What do I do if a restraining order is filed against me in Connecticut? Attorney Donald Beebe explains that. To begin with, if a restraining order is filed by somebody other than the police or prosecuting authority, those orders require a hearing. You should have a lawyer represent you at the hearing. You should never go to one of those hearings alone, and you should never miss those hearings. A person who violates a restraining order faces a Class D felony, which is up to 5 years in prison and fines up to $2,000. It can pretty much put you out of your home and away from your family and your personal belongings. Additionally, an order of protection is issued when there has been a family violence arrest, usually a disorderly conduct or something more serious than that. Generally, the defendant is ordered to go to court the next day. On that day, the defendant is arraigned in court. He has the right to challenge the order that is being entered at that time. This is called a Fernando hearing, based upon the case of State versus Fernando in Connecticut. If a defendant does not ask for a hearing on that day, he loses the right to challenge the underlying facts to the order of protection. He cannot come back at a later point and say that the claims that have been made by the person who claims to be injured or the police were not correct. Once that arraignment occurs, the judge enters the order, and if the defendant does not ask for the hearing, from that point on, the defendant can only show that conditions have been changed somehow to the better and seek a modification. This is a fairly complicated matter, and it happens very quickly. Therefore, when you get arrested for a domestic violence matter, you should immediately contact a lawyer. It may happen at night. Our office has an answering machine, and we listen to those messages. For a free phone consultation, contact Attorney Donald Beebe in Norwich, Connecticut at 860-889-5266 or visit www.beebeandoneil.com.